What's up everyone, it's the Law School Lumberjack. I hope you're having a wonderful day. Today we're going to do another installment of our Property Law 101 series, Fee is Not Simple, and today we are dealing with the Powers and Powers Estate case. So this case really delves into the responsibilities of a life estate tenant when it comes to the expenses and repairs associated with a property for which they have a life estate interest in. So if someone has the right to a life estate in a property, they have the right to possess the property or rent out the property for their lifetime until they die. Once they pass away, there is a gift over to the remainder man who holds the property in fee simple. So the general rule is that a party who is entitled to a life estate is able to get income from the property or rents from the property, but they are not allowed to mortgage or sell the property, which is called encroaching on capital, unless the grant or will or testamentary document that gave the life estate allows for it. So that's a bit of a primer for this case, so let's move on to the facts. So Mr. Powers passes away. His will is probated, and in the action associated with the probate, the court holds Robert Powers was given a life estate through the will that allowed him to encroach on capital for the purpose of maintaining the property. Time progresses and there becomes some questions and dispute as to what expenses Robert is allowed to encroach on capital for and which expenses Robert has to pay either out of his own pocket if he's living in the property or through the rents he's receiving if he's renting out the property. In other words, there's a question as to whether or not certain expenses have to be paid from the income of the property and whether or not certain expenses can be paid from the capital of the property. So in this case, there's kind of 5 categories of expenses that the court has to consider whether or not there are items that the remainder man should be paying, in other words, should be paid from the capital of the property, or ones that the life estate tenant should be paying, also known as paying from the income of the property. So there's heating costs, repair costs, insurance premiums, taxes, and the mortgage. So essentially what the court holds is that because a life estate tenant is essentially a tenant in the property, or they're holding the property for a period of time or possessing a property for a period of time, they are only responsible for the daily maintenance of the property. Any items that are for the long-term preservation of the property or to prevent waste in the property should be paid by capital, or in other words, should be borne by the remainder man. So what the court ends up doing is they go through these 5 different categories of expenses and try and figure out who should be paying it. Whether the life estate tenant should be paying it from income, or whether the life estate tenant is entitled to encroach on the capital of the property by either mortgaging, selling, whatever it may be, in order to pay those expenses. So the court goes through all 5 of these categories. The first one being heating costs. The court says, well, the person who's living in the property is enjoying the heat and they should be paying for the heat. The remainder man's not in the property. He's not getting any benefit from the property. And as a result, that heating cost should be paid by the life tenant. So now let's move on to the repair costs. The court has a bit more of a nuanced approach to this topic. While heating was very clear, repairs is a very large topic. There could be different types of repairs. So what the court essentially says is if the repairs are for the long-term preservation of the property, so if the repairs are for things like a dripping roof, the actual bones of the property, such that if the property would waste without this being done, then that is something that should be paid from capital. However, if the repairs are something for the day-to-day enjoyment of the property. So for example, repairing parts of the garden, mowing the lawn, things like that should be paid from the income of the property. And that makes sense because the life estate tenant is getting the benefit of the day-to-day, whereas the actual structure of the building, the preservation of the property, benefits the eventual fee simple owner being the remainder man. As an aside, another thing the court says, just in case it ends up on one of your exams, is that unless painting is to preserve the property, the cost of painting the property will be borne by the life tenant. It took me a while to wrap my head around this, but it makes some sense because let's say I'm a life tenant and I want to paint the property blue. Well, that should be borne by me. Now, if I'm painting the property because without me painting the property, the city's going to come and place bylaw fines on the property, then it's for the benefit of the remainder man and it could be paid from capital. But if I'm just painting the property because I want it to look nice and it makes me happy because I like the color blue, that should be paid by me as the life tenant and not the eventual remainder man. So number 3, we come to the insurance premiums. And the court holds that if the insurance is for the bones of the property, the structure of the property itself, then those insurance premiums can be paid from capital. Conversely, if the insurance is for chattels in the property, or in other words, things owned by the life tenant, then that insurance should obviously be paid by the life tenant and be paid out of income. Fourthly, the court looks at taxes. This is an easy answer for the court. Because the life estate tenant is living in the property, they're getting the benefit of the property, they're getting the benefit of the utilities that the municipality is providing at a certain period of time. Those property taxes should be borne by the life tenant and paid out of income. And fifthly, and finally, we come to the mortgage. And this one's a bit tricky, but essentially what the court says is sometimes you can have interest-only mortgages, in which case, if it was purely an interest-only mortgage, then the payments would be made solely by the life tenant. However, as I'm sure you're aware, a lot of times mortgages have 2 components. There's a payment of interest and a payment of principal. And that gets amortized where these components over time shift. So at the start you have a lot of interest being paid and a little principal, and as time progresses the payments stay the same, but what's being allocated to principal gets higher and what's being allocated to interest gets smaller. So essentially what the court says is if you do have like a blended payment where you've got principal and interest being paid, the portion that should go to the interest gets paid by the life estate tenant. However, the portion that goes towards the principal in the end benefits the remainder man, so as a result any principal payments can come out of the capital of the property. So the ratio of this case, as I said before, is that in general daily maintenance expenses should be borne by the life estate tenant and should either, if the life estate tenant is living in the property, should be paid directly by the life estate tenant out of their own pocket, or if they're renting the property, it should be paid from rents. Conversely, the long-term preservation of the property should be paid by capital, either by the remainder man or the life estate tenant can dip into the capital of the property, usually through a mortgage, to pay those costs. Now, I'm sure you're wondering, how do I apply this in a law school exam? So let's say you have a fact pattern with a bunch of different expenses and a party with a right to encroach on capital. The question becomes, what items can be paid from income? What items can be paid from capital? The general rule that should be going through your mind is that if it's for the benefit of the daily use of the property, it should be paid from income, or in other words, paid by the life tenant. If it is for the preservation of the property or to prevent waste in the property, it should be paid by the remainder man, or in other words, paid from capital. So one good example that hasn't been touched on in this case, because the property was a non-condo or non-stratified building, one thing you might want to consider, or you might see on a law school exam, is something to do with condo fees, for example. So if you see something on, let's say, a law school exam that deals with condo or strata fees, don't panic. Just apply the ratio to determine whether or not those condo fees are associated with the general maintenance or the general day-to-day expenses, or if they're to do with the preservation of the property. As I'm sure you're aware, if you own a condo, there are monthly condo fees. The person who's benefiting is the person living in the property. Those condo fees should be paid by the life tenant as a result. However, sometimes if there's a problem with the building, you have to pay what's called a special levy to help the condo association or the strata corporation pay for the costs of fixing that big problem. Well, clearly that big problem, such as replacing the boiler for the strata unit or replacing the roof for the building, would likely be for the preservation of the property and would generally be paid from capital or should be borne by the remainder man. So, if you see expenses that don't show up in the powers and powers case, don't be alarmed, don't panic. Just remember, is it for the daily benefit of the party who's living in the property, or is it for the preservation of the property as a whole? I hope this video was helpful. If it is, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. See you next time.